From Houston, Texas, and Cypress Radio in Cypress, Texas, home of the Houston Astros. You've tuned in to the Special Ed Section 504 Radio Hour, and I'm your host, Louis Geigerman. Welcome back. Well, it's been a while since we've done this. We're going to do another edition of the Good, the Bad, and the Ugly. And here's my associate, fellow COPA member, fellow TOPA member, and all around good buddy, Pat Freeze.
Hi, everybody. Thanks, Lou, for having me today.
Oh, you're welcome.
Seems like it's been a while.
We have, but it's been a while, which means we have a lot of cases that we can really analyze whether they were good, the bad, or the ugly.
Absolutely.
So
Absolutely.
getting into it, let's talk about what we've done that has been really good.
Okay. Hey, Lou, before we do that, I was just having a thought before we came on the air.
Yeah.
Because when we talk about one of these cases, I'm going to kind of go into how I approach it. And I thought perhaps we could take a minute or two and just talk about what advocates do and how we might look at things differently, like what's our background, so that people who have never worked with an advocate before would. A lot of times I hear parents say, I never knew about advocates. What do you do? And so I thought, if that's okay with you, we just talk a little bit about what we do before we jump off into it.
Sounds good to me.
Is that okay with you?
Go for it.
Okay, well, I'll just kind of quickly give what I do, and then if you can do. So I got into this because I had a child with a disability, and I was looking for didn't know about advocates, but somebody said, "Oh, you need an advocate, and you need to call Louis Geigerman." And so I called Lou, and at the time, my situation, it was actually my grandchild. My grandchild was in a different location, and it was going to be quite expensive because we were in those days traveling. Advocates have to travel, and you have to build that into your rates and stuff. And so Lou said, "But you can do this." And so he helped me with some forms and everything, and I did kind of approach it. That's kind of how I started really getting into advocacy. And then I said to Lou, I want to do what you do. And I finally wore him down, and he said yes. And he agreed to
you really did wear me down.
I think your exact words were, "You're not going to leave me alone till I hire you," I think is your word. And so I said yes. And of course, I thought it was going to be like I was going to get a job. He was going to hire me and pay me. Well, that's not how it works exactly. But he did agree to take me under his wing, which he did. And we have since become just best friends. And that's been like at least about 10 years or more since then. And our families know each other, and we've been together on holidays and things like we don't go off on holidays, but on holidays, our families sometimes get together. But I came to this with a background as a litigation paralegal. Forever, I had worked at law firms and helped get ready for trial and get the documents ready and help get the witnesses together and all of that sort of stuff. So I had a little bit of a legal background, and I had left the law firm just before that because I always thought I wanted to be a teacher. And so I took an alternative certification course from the local community college here, and finished that and became highly qualified, as they called it, in reading, language arts, English language arts and reading, grades 4 through 8, and as a generalist, grades 4 through 8. But I didn't do the student teaching, so I never became certified. So I had that behind me. I'd sort of, okay, I know the kind of the legal side of it, and now I'm kind of been exposed to some of the school stuff. And so I thought this would be a great a great fit for me. And so I sent Lewis all of my letters of recommendation that I'd had people write so I could get a job being a teacher. And I don't think it mattered much to him anyway, but so he said, yeah, he would do it. And so I started attending meetings with Lewis, and he gave me a list of things that I needed to study. And boy, did I study, because being a person who's, as old as I am, never happy with where I am, I had just taken the law school admission test. So I think I just like to study is what I think I like to do. So I began to approach special education like I had, applying for law school, which I didn't go, but anyway. And so I studied like crazy. I went with Lewis to all of the meetings, and he finally said, hey, you're good to go. And so I started to try to tell people that I'm out here, I can help you. And eventually I built up a client base and referrals. It's all word of mouth. Somebody that I've helped that has been happy with my services tells someone else, and that's how it goes. So I was quickly able to put the law firm experience to use, because Lewis and I took a case to due process. And that's when as a parent, you file against the school, and if the school and the parents can't agree, there are a couple of things they can do, but ultimately you can file a lawsuit against them. And it's not a lawsuit in the courts, it's a lawsuit with the Texas Education Agency, right, Lou? Yes. And it's heard by an independent hearing officer. So Lou and I prepared a case, and we had a 3-day hearing in front of the hearing officer. We lost, but that wasn't probably unexpected. I think most of the time, probably I couldn't guess. There's probably a percentage out there, but I would guess 95% of the time cases are found in favor of the district. So there's a really high bar there, but we had fun. I think we did a really good job, but so there's that. And so that's what we do. We go with parents with all of this experience that we have. And Lou's been doing this for how many years, sir?
28
years. And in the meantime, we go to, there's an organization we're members of, the Council of Parents, Advocates, and Attorneys, or Attorneys and Advocates. It's
current attorneys and advocates.
It's a national organization, and they have a seminar.
The acronym is COPA, COPAA.org. If you want to
COPAA.org, and parents, advocates, and attorneys can join that. There's a nominal fee, and we have a conference each year, and we go there for training. Don't forget TOPA. Don't forget TOPA. I'm about to get to TOPA. So COPA is national, and now we have TOPA, which is the Texas Organization of Parents, Attorneys, and Advocates. Lou and I are both on the board of TOPA. Lou is actually the president of the board, and TOPA is sort of like, we're not under COPA, but we're sort of modeled after COPA in that we provide training, and we hope to have a voice in the Texas legislature for educational matters, special educational matters. So any parents out there that are interested, we would love to have you join TOPA. It's TOPAA, and also COPA, COPAA, and both are just a wealth of information and getting to know people in our community and for advice. It's a great thing. So
it's COPAA.org and COPA, COPAA.org, if you're looking it up on the internet. Okay.
Right. So I just wanted to stress that about all of the training. Like I said, Lou's been doing this for 28 years. He is the guru. He knows pretty much everything off the top of his head. I attended a week course at William & Mary College designed for advocates and attorneys, which was very helpful and full of information about that. And then we do the COPA every year. And Lou has presented at COPA numerous times. I've presented with him once, I think. Anyway, so I just wanted to tell you that we're not just people out there like, oh, let me go strong arm the district or whatever for you. We know what you're going through. We've both been there. And we have trained and studied, and we study all the time. Okay. So I just wanted to tell you that's what we do, and that's where we're coming from. Thank you, Lou, for that platform to be able to say what we do.
I'm glad you did, because I think, you know, we're hopeful that a lot of a lot of people that hear this show are in COPA. A lot of them are parents, and, they're trying to find a way of how you navigate through this. And, that's what we do, is we help families navigate. And it's, we constantly are learning. One of the, we try to keep abreast of, what happens in the courts. We have to, because that really has a impact on what we do. Obviously we're not attorneys, but we still have to be mindful of what the legal framework is, so that we know how to be able to help our clients. So thanks for that. I think that was really helpful. What I want to do is I want to segue to what our practice. And I've been doing this for a while, where I've had a segment called The Good, the Bad, and the Ugly. I used to do it quarterly. Hasn't been happening that frequently this year, in the last couple of years, but it's about time. We've got things going on that I think are important, because I think as we talk about what was good, what was bad, what was ugly, it's a learning experience for families to really understand how you navigate, and maybe things that we might be doing differently to try to make them all good, as opposed to having the bad and the ugly. So let's talk about things that happened that were good. Recently, we've had some good things happen. One thing, go ahead and talk about the MDR first.
Okay.
And then I want to talk about the recent case that went to the Fifth Circuit, that made a real important decision here for Spanish those that speak a second language. So go for it.
Okay, I will. And I just want to say also that that you and I each have our own business. You have NARDA and I work under NARDA, but I also do my own things from time to time. But together we sort of have this business where we kind of specialize in discipline cases. And we have actually a website. Can't think of the name of it right now. School. I'll have to think of what it is. I have to tell you that.
Schooldisciplineadvocates.com.
School Discipline Advocates, right? And so we that's kind of something that we think we specialize in. We've had pretty good success defending students in manifestation determination review meetings. And so typically what happens is a student who is served under IDEA or 504 for that matter, but mostly IDEA. It's a kind of a different path where 504 violates or is accused of violating the student code of conduct. And so there are two different sides. There's the gen ed side and the special education side. All students are subject to this, well, unless they're exempted from it, the student code of conduct and the discipline that is can be imposed for violating that code of conduct. However, if a student is covered under IDEA and if the violation of the code of conduct can be shown to be caused by or directly and substantially related to their disability, then there's a whole different thing that has to happen. So what typically the school will do, and this is what we've seen, is the school will call together the meeting. It's called an MDR meeting, again, manifestation determination review. And the school's position a lot of times is pretty standard. No, it didn't have anything to do with it. right? That no, the kid, no. Even if it's directly related, nope, they didn't do it. They want to send them off to the just to an alternative educational placement. So we go in and I'm going to tell you about one particular district. I'm even going to say the district. The name of it is Denton ISD in Texas. This is, I guess, near Dallas, Fort Worth, up that way. And there are two different schools within Denton. This particular client had been accused of violating the code of conduct at one school, and that didn't go well. And then through a series of things, anyway, the student ended up back in the district, but at a different school, which looked at it entirely different. I mean, it just a lot of times depends on the personnel there at the school and how we're able to present the facts. So the school that just did a wonderful job at the MDR, I'm not going to say the name unless Lou wants to, but there was one particular male licensed specialist in school psychology, an LSSP, who was fantastic. He had met with the student, he had got to know him, and he offered some wonderful information. And then another teacher who is the teacher in the behavioral room. And both of these gentlemen, I just want to give kudos to them. So, you know,
Go ahead and name the names. They deserve to have an accolade.
Do they?
They do.
All right, give me just a second. One is Coach Earl Horton at Denton ISD, not sure exact school. And the other is Mr. Ochang, who is the LSSP. You guys did this kid a solid, and I thank you from the bottom of my heart. If every LSSP and administrator or teacher had the same compassion and understanding and intellect that you guys have, Lou and I would be out of jobs. So kudos to you guys.
You're here.
So yes. Well, this was a reconvene. So Lou had attended the first section of this MDR and they didn't get through. And the father had said to Mr. Ochang, he said, if you would just get to know my son, can you just go visit with him and get to know him? And you're going to see that what they're saying is not right. And to his credit, Mr. Ochang did. He went and got to know this kid. And so, and I think it probably would have gone well just based on that. But I wasn't at the first meeting. I told Lou, I said, I'm going to lay this out linearly. And this is how I think. Step 1 leads to step 2, leads to step 3, leads to step 4. In this case, and for those of you who are going to attend an MDR, if you happen to do it without an advocate, this is what I would suggest to you. The first thing you want to do is look at the evaluation, the most recent evaluation about a student's disability. Read everything about it. I'm not talking about their eligibility either, but their disability. Do two different things. You look at their disability, and then you look at the eligibility that the school came up with. Then you look at the individualized education program, the IEP. What did the school put in place for this? Are there goals? A lot of times there are behavior goals. And then we look to see if there is a behavior intervention plan, a BIP. So in this particular case, I read to the school and I said, I want you all to hear this, right? I want everybody in this meeting to hear this. I read the particular points from his evaluation that spoke to his disability doing the exact same thing that he's being accused of. I said, and actually I'm going to tell you what that was. Our student suffers from an emotional disturbance. He perceives things. Actually, I wish I could read it. He makes like a mountain out of a molehill, really. And his go-to is to be aggressive, be physically aggressive, verbally and physically aggressive. So one student got in his face and said, give me your snack. Our student said no. The kid got really in his face, started punching him and started calling him racial slurs. Our kid did the same thing, called the other kid racial slurs. Our kid stood up in his chair, punched the other kid in the mouth. Okay, that's what happened. And he sat back down. So the way the school described it, they put a lot of modifiers in there, like the other kid had excessive bleeding, and the other kid asked him for a snack. No, he got in his face and demanded it. So you have to kind of tease these things out. And so I said, he didn't ask for it. He didn't approach, our kid didn't get up and approach him. He stood up and hit him. And excessive. But anyway, my point is, these are exact same things that are described in his evaluation that he does. He hears things, he doesn't process it right. He has an emotional disturbance, right? It's not a quick temper. There are reasons that he does this. So I made the point. This is exactly the kind of behavior that you guys have written goals for him. It's the exact kind of behavior that is addressed in his behavior intervention plan, physical aggression. So how could you say it's not a manifestation of his disability? And so really what I wanted to say was that I read it linearly, for them. So when I finished my little speech, Mr. Ochang said, "You're right. And I believe that this was a manifestation of his disability." And it had previously been suggested that this student needed to be in a more restrictive environment, a behavior class, so to speak, to help him get these emotions under control and to help him find different ways to respond, that sort of thing. So this school said, "Hey, you're exactly right. We propose moving him to this class where he's going to get instruction from Coach Horton, who got it. He got it so much. Coach Horton, thank you. And he will work to go to out classes. They're going to first work for him to be able to go out to football, to his gym class. He is football, and then other classes. And at any time that he has an issue, he can come back to this class. It's just the best of, it's the best, it's what we've been asking for." And did I leave anything out, Lou?
Well, no, but I would say this to you. I agree that we should look at things from a linear perspective when we're doing this. And one of the things that you were saying is you not only look at the disability itself, but how it manifests itself, and look, the attributes, the symptoms of that disability. It's very, very important. And that's what I try to lay out in the previous ARD. I'm not undercutting what you said at the second meeting, but frankly,
Right.
they had already made their decision that he was going to that they decided that it was a manifestation, and I think a lot of it had to do with the fact that Mr. Ochin sat down with him and really did get to know him. So
And that's what you and the dad had asked for. That's what you guys had asked for in the first meeting. Yes.
That's right. But I mean, but the lesson for parents though is, well, actually there's several lessons. One lesson is absolutely, as you said, look at it from a linear basis when you're making a case that it was a manifestation of the disability. Remember, if it's not a manifestation of the disability, they can punish a kid under the student code of conduct, whatever that would be. And so if it is a manifestation, they are limited in what they can do. Now, we can go deeper into other cases about like the Klein case. We can talk about cases um, where districts are saying that there's a weapon, or serious bodily injury.
We had one of those last week as well.
That's right, serious bodily
Mhm.
injury, or or drugs were involved. And so it's very, very important to look at that, but try to have a dialogue. The problem is the well, here's the thing that's important to me. The most important part of an MDR, besides what I absolutely agree with what you said, that you need to look at it from a linear perspective. But the person that you really need to reach in this case, frankly, you only really need to reach one consensus member in the group. That's key. And the person that you really need to reach is the school psychologist. They are the key player, because frankly, really most of the time the committee will follow the lead of the school psychologist. And they have an ethical responsibility to do the right thing. Yeah, some will say that the administrators have an ethical responsibility. The thing is they don't have the professional knowledge that a psychologist would have under these scenario, and they are really the professional that everybody looks to. So when we're building this, we look to the school psychologist. Now, another thing that's important, depending on where the district is going with it. Sometimes if it's, if they're playing, I've found school psychologists that can be hard-headed too, you know. And so one of the things that I do, and this is not my original idea, I'm going to give credit to Peter Wright of Wright's Law on this, and that is, um, if you're able to, if you can get a psychologist to see your child that has been accused and do an assessment of the student, and then compare the misbehavior to the symptoms of the disability and do a write-up on that, that's really effective way to do it too. Now, will that cost money? Yes, but if it looks like something may want to go to hearing, that's how you would build an expert into the case. And a lot of times, bringing that in, if you could bring that in even into the MDR, unfortunately, a lot of psychologists aren't that nimble to be able to do it quickly, but they have to compare, they have to look at the individual's disability, compare the maladaptive behavior of what they're accused of to their actual disability, and then make a determination of whether it was directly and substantially linked. They can't simply write a statement, oh, it's a manifestation of the disability, which a lot of times physicians have a tendency to do. You can't make a conclusory statement, but you have to compare the symptoms of the disability to the maladaptive behavior. And I've used that too effectively when I've had to that stave things off to go to trial. But in this case, there were you had to have people that were open-minded enough to be able to go to the next step and interview the student and then make a determination from there. And for that reason, that ended up being a good story. And because we thought that we were beating the drum to having to go to a 20-day expedited hearing on this case, but people did the right thing. And particularly, kudos to the coach, kudos to Mr. Oshing. It ended up being a good story.
Yes, excellent. Exactly, Lou. One thing I will tell parents, a lot of times when the student's disability is ADHD, they'll try to get around it saying, well, this wasn't an impulsive act because he had time to think about it, or something else they'll throw out is he knew right from wrong. He knew it was wrong when he did it. Those are not defenses. You can't do that. You can say, well, I don't want to I'm not practicing law. I mean, I'm just saying, I don't believe those are good defenses. The right from wrong standard, I think, has been dropped, right, Lou? That's not an okay defense for the schools anymore. But that's why it's so important to read back through all the documents, the present levels in their IEP, where the teacher may have said, because the school will say, well, the student hasn't acted that way before, so we don't think it's a manifestation, even though the description of the disability may say that's one of the things that can happen. Well, this child hasn't shown that. But a lot of times, if you go back in the document, you'll see, oh, yeah, actually the child did show that before and the school ignored it.
Right, and of course so we got them to agree that there was a manifestation, but they also agreed with the second question, that they had failed to implement the IEP. They didn't implement the behavior intervention plan properly. They had
Right.
a substitute teacher that was there that day and really was not aware of that particular BIP, or did not go through the steps. Not only that, the person that, if I'm not mistaken, it was the principal that had made these allegations, that the student approached the other student, and he wasn't in the classroom. He went by secondhand information to say that's what happened versus the truth, where our kid would just stood up. The other kid was hassling him and punching him and giving ethnic slurs. So it wasn't approach. He just got up and smacked him in the mouth. As far as the
Right.
accepted bleeding, he bled from the mouth. Whoop-de-doo.
Yeah.
That's not, that doesn't get there. So, you know,
Mhm.
of course, there's a point of me saying, if somebody's saying ethnic slurs to me, that's, that's pretty bad too. So
Is
that's
that what happened to your arm, to your wrist there, Lou? Somebody, he just held it up.
that's it. That's exactly right. All right, I want to segue for a second into something that you had been involved with back a couple of years ago with Hank Bostwick, an attorney who's now in North Carolina. And if you're out listening to us, Hank, hello. You're a wonderful lawyer that was here in Texas. Uh,
Brilliant.
brilliant,
Brilliant.
brilliant attorney. I mean, wonderful trial lawyer. Really good and brilliant. Really excellent. Just excellent in trial. Really, really good. Um, Edgar Pacheco, who works with us, and you were involved with it, at least peripherally.
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 We had a Spanish speaking client, and there was a difficulty, and for her, in fact, she didn't speak English at all, as I
We
recollect.
had several, Lou, we
In
had
fact, there were
several
three.
around the
There
same
were like
time,
three.
Spanish.
Three. Why don't you do the setup on it,
I'll
Penelope?
set it up for you. Okay.
Yeah.
So when Edgar Pacheco came to work with us, to be trained by me and by Lou, and Edgar his first language is Spanish, and he speaks it so beautifully I could listen to him for hours. But Edgar brought a lot of Hispanic clients into us, and these are people that speak enough English to maybe get along at their job if they have menial jobs, but really don't speak the language. And what we were finding was that at ARD meetings, they're supposed to be interpreted, and the school would provide an interpreter sometimes. Sometimes it would be the school principal who spoke Spanish. In this case, it was Spanish, but this could be Vietnamese or any other language that the parent speaks if they don't speak English. And so we found that because Edgar was speaking Spanish or could speak Spanish, he would say, well, that's not a proper translation, or, that's not what they said, whatever. So we were finding a lot of issues with this. And so I think this was sort of on Hank's radar to begin with, Lou.
Yeah,
And
yeah, yeah, it was. It was. And I'll tell you what happened. These cases, because these individuals were having difficulty communicating in our meetings, and that they weren't getting effective translations of all their documents, the previous administrative code in Texas was, it said, it said if a person was unable to speak English, was unable to speak English, and well, through the courts, we had a recent decision. Again, thanks to Hank pushing it. Also, Disability Rights Texas was involved. They have changed. The now Texas Education Agency has actually changed the administrative code now, where they changed the language where a person was unable to speak English, and now it's been amended to say the school district must. This is important for everybody that that's a non-English speaker. The school district must take all reasonable actions necessary to ensure that the parent understands the proceedings of the ARD committee meeting, that's an IEP meeting if you're in other states, including arranging for an interpreter for parents who are deaf or hard of hearing or whose native language is a language other than English. That's a heck of a lot more than just saying unable to speak English. That puts a lot of a high bar to school districts to make sure people understand exactly what is being discussed in those meetings. So, thanks to the efforts again of Edgar, to Hank in particular, and Disability Rights Texas, and Pat, you were there originally. Um, Thanks to that, this is going to have a tremendous impact for non-English speaking individuals, or those who are hard of hearing, or who are deaf. It's a huge, huge issue that will help these populations just immeasurably. So, hats off to you.
Right. And one thing about that, and we always want to make sure that parents are able to have meaningful participation in the meetings. And if you can't understand it or you don't know what's going on, you can't participate meaningfully. So this speaks to that, their meaningful participation.
Well, congratulations. That's a huge deal. And so that is really a great thing.
Yeah.
The other
Yeah.
things that haven't been so great. And so I think I want to switch gears here and talk. It's hard to determine whether this is ugly or bad. I think this is really ugly, but this is regarding the Klein case. We had a young man that came to school. Let's see, his challenge. He was in the spectrum. Is that correct, Pat? Or I can't remember what his challenge was.
I can't see it. I'll have to look real quick. I can't remember.
I think
Go ahead and I'll look for it.
I thought he was, but what he
Maybe
did,
ED, but I'll see.
I thought he was in the spectrum. But anyway, he brought a a clay cutter to school that actually was part of his art kit. Now, if anybody's seen a clay cutter, it's I mean, it's got a very flimsy blade to cut clay, and it's not more than maybe an inch in length, right? And he had this at school, and they decided that this was a dangerous weapon. It wasn't 2.5 inches, according to the penal code or anything, and he wasn't threatening with anybody on it. And he made some stupid jokes about it, with put a Campbell soup can on it or something, with a PowerPoint. They decided that he was like a danger. This was a weapon, and this was dangerous. Frankly, a pair of scissors were a bigger threat than this thing was. I mean, this thing
a sharp pencil would be a bigger threat.
Yeah, a sharp pencil.
Oh, Lou, by the way, this child is gifted, but has autism and an emotional disturbance.
Yeah. So, we said, hey, number one, it's not a dangerous weapon. Number two, he wasn't using it as a weapon. He never threatened anybody with it. But Klein said, oh no, he's a danger. He's got to go to alternative school for this. We went to a hearing, and incredibly, the hearing officer sided with the school district, sided with the school district, and parent, took the student out of school. But now the case is in federal court right now. But it's like, I don't know why this case ever got to where it was and how this got so twisted. But this one really impacted me. This is ugly. I mean, this is like, can we come to our senses? You guys are acting like this kid's like the Unabomber. I mean, he's not. There was no threat. It was just, I think schools have gotten so scared now after all these school shootings and whatever that they've knee-jerked. They've gone from one extreme to another extreme, and it's really been to the detriment of our kids. I mean, do you have any thoughts
Yeah.
about that?
Yeah, that case is just absolutely ridiculous, just crazy. It reminds me of another MDR that I had recently, a student with an emotional disturbance who it's recommended that he be kept away from other students for his safety and for the safety of other students. That's part of his IEP. So he's in a classroom with a child who has, it's disputed whether the child has brittle bone or some form of something that requires him to be in a wheelchair most of the time. So it seems that our kid, who needs to be kept away from all other children for his safety and theirs, was apparently table partners or something with this other kid who he thought he flickered him off. And so the other kid said, no, he was pointing to something with his middle finger. Our kid thought he had been flickered off. And so he said, don't flicker me off. And
No, the word is flipped off, not flickered.
I know, but he said
Flipped
flickered,
off.
and I thought that
And
was so cute.
we all know what flipped off means.
Right. So he thought he flipped him off. And so our kid, because he has an emotional disturbance and he doesn't react well to things like that, pulled the back of the chair from the other kid, and the kid tumbled out of his chair onto the floor, supposedly fractured his coccyx and is unable to attend school. This is considered serious bodily injury. We don't have any, and actually they filed charges, police accepted charges on this, and our kid is like second grade. Police accepted charges for, bodily injury, assault, I guess. So I was able to get the school to say yes, that it was a manifestation of his disability. Okay. However, because it was serious bodily injury, they still are going to move him to an alternative placement.
But
in this case,
but it's limited to 45 school days.
It's limited to 45 days. But in this case, it's a very therapeutic setting. So I don't think it's the worst thing that could happen, but mom did have to hire a criminal lawyer, and they're still, still defending it on that side.
Well, originally,
so it's gotten crazy.
Originally, they were talking to send him to juvie, as I recollect. And so basically what we were able to do was create.
Well, they're still sending him to juvie, Lou. It is still juvie.
Still
it's
juvie.
County juvie,
Okay,
but the way the lady described it, very therapeutic.
Right.
To meet his needs.
Yeah, but they're limited in the amount of time that they can send him there. And so that was somewhat of a softer landing than what they originally were going to do. They were going to send him away for like till the end of the school year. So it just,
expel him. Yeah, they were going to expel him.
You're right. They were going to expel him.
Mm-hmm.
And they came off of the dime on that. So that was kind of a partial win, but it is what it is. I
Mm.
mean, what do we do? You know, a lot of these ugly scenarios seem to come from MDRs. And that's, I mean, I guess you and I get pretty jaded because we do a lot of these, but the truth of the matter is, the schools, I've found that the disciplinarians who are largely the associate principals or the assistant principals, they're looking for their pound of flesh. I mean, we could talk about school districts we've had difficulty with. One would be Danbury ISD. That one we've had constant scenarios about how they do things, and others. Um, the thing is that these people don't care. They want to get their pound of flesh and send these kids up. The problem is they don't they're not using restorative justice enough. All they're doing is they're setting a kid up to do the school to prison pipeline. They're
Mhm.
setting these kids up, sending them to, most of the time, sending them to these schools, most of them. They're punitive in nature. They're highly regimented. They've got some kids that have done some really, really bad
It's
things.
prison. It's school prison.
It's school prison. And all you're doing is you're at a formative age, you're making a kid angry,
Mhm.
bitter, and that's a stepping stone for them to, to go a different route where they could end up being incarcerated someday. We're not thinking enough that what we have here are adolescents. We have children that do not have mature minds, and we need to find other ways to reach them than being punitive. I just, I just, it's arcane, it's wrong, and that's why, frankly, why we do a lot of these cases because we're trying to save these kids. Um,
Mhm.
you know, things that I would say to parents, and I've said before on this show, you've got to have everybody needs to have the talk with their kids. And for those that are advocates out there and you have clients, you need to tell your clients, parents of your clients, you need to tell them to have the talk with their kids. When you're accused of something at school, clam up and say, I can't talk to you until I have my parents present. What they're doing here in the state of Texas is very scary because in the last session of the legislature, again, some of this has to do as a direct result of the Uvalde massacre. They have state law that they could have a school resource officer in every single school. And from
Uh,
my perspective, and I think I can certainly speak for you, Pat, that's a non-starter for us because what we find
oh,
a guy with these people genuinely, these police officers, and Pat's got a police officer in her family, but police officers, if you have a cop thinking like a cop and they're in a school situation, they're going to be looking at things that really are things that aren't really an issue that really should be managed by behavior intervention plans as opposed to having something to be adjudicated. And I've really get up on the soapbox on it because I think it's incredibly dangerous.
it is. It is. And they're cops first. My husband's a cop. You probably all have heard me say this before. He's a good cop, but at any rate, um, I know a school resource officer that supposedly is loved by all the kids at school. And I heard him, he said it to me. I'm just waiting for this one little bastard to mess up, and he didn't use mess, so I can get rid of him. That's their mindset. is somebody's kid there. He's just waiting for him to mess up so he can get rid of him. Those are your school resource officers. Oh, Miss So-and-so, she's sweet, she's wonderful. These people are cops first. Cops first of all. And you know, Lou, there are two kinds of people in this world. There's prosecutors and the cops are all on that side. It's like, let's get them, let's find them, let's get them, let's punish them, right? And then there are people like you and I who, hey, why did that happen? How can we restore this? How can we make this person whole again? And that's what we're having. And we're seeing more of the school people are on the prosecution side. It's like, let's get them and punish them and get them out of here. And us and the advocates that are out there are, how can we save some of these kids from that?
Well, you know, what I believe, and I've heard other people's espouse this, and I actually subscribe to that. If you have we have to deal with the reality that school resource officers are going to be in the school. Let's get them invited into the ARD meetings. Let's make them come to the ARD meetings so that they're aware of the behavioral challenges of the children that we're dealing with. Because what the last thing we want is our kid to be, be charged when it's something that's part of it as, part of that. And frankly, having that school resource officer in those meetings can be effective because we will explain to them, here's an intervention plan. This is what we're supposed to do, A, B, C, D, and E. And frankly, if things go awry, those people can be put be called as witnesses. It said, you were there. What did you do when you had this information?
Right.
I think we should be.
That's a great idea.
I think we should be inviting them to the ARD meetings because invariably they could it could be an issue.
But the schools will not let them come for the most part. You know that parents can invite them. Parents can suggest.
No,
the school will say they're. I think they'll say they're not a school employee. We can't make them come.
Actually, they are an employee of the school district, and if they say no, that could be an issue too.
Mm-hmm.
Said, look, we invited that person to be there. And and we wanted to explain to them what the behavior intervention plan was. And if they said, no, we're not, I wonder what that would look like to a hearing officer.
Yeah, that's true. Very interesting. There's a lot of things to explore around that, this whole SRO issue.
Yeah, but I do want to get back to, I think it's important for there to have the talk. I think parents absolutely need to, I hear parents, you always, you think honesty is the best policy. Sometimes it's just better to shut up, and let the adults take care of it. The problem is, they're going to bear down. The administrators are going to bear down. They use investigative techniques or interrogative techniques that the cops do. They've been taught. They already figured out who the person is, so they're going to gear their questioning to nail this individual. That's how the cops work. And it's important for the parent to be there with the kid, but they've got to understand that the administrators will yell at them, will get in their face, that will push their buttons, and they'll scare them and say, you're going to go to jail if you don't talk to me. And they have to drill it into their kids. Well, no, you're not. And I'm mommy or dad. I can't talk to you without my mommy and daddy present. And it's really a difficult thing to expect a child to stand up to these administrators that yell at them. They're bigger than they are, and they have more, they're bigger and more.
And children are taught to respect them as well.
Right, but we've got to have the talk because too often we find kids say things that may not actually be true or are incriminating that actually aren't really as they were. and that makes things even more difficult, and
Mhm.
makes it more difficult when we come in and do an MDR.
Right. And Lou, if somebody takes exception to the fact that you said, oh, that's how the school does it, I would just point them to the REID technique, REID. That is a technique that police officers, it's a training that police officers take for interrogation. And the REID method is offered as a course for school administrators. So if you think Lou's just, you know, look it up, the REID technique, a course for school administrators, and you'll find that they interrogate these kids just like cops, and they come from the perspective of, we know you did it. Now, it's going to be easier on you if you just fess up and that sort of stuff. That's not fair to these kids. That is completely not fair. So,
Yeah. Yeah. So do we have anything else to talk about MDRs today
oh, we
to
could talk all afternoon, but we're probably starting to bore our listeners. But yeah, I
yeah.
think I'm done.
Okay. Well, I'm wondering if we have any other guidance that we can provide. I suggested, having the SRO, requesting that the SRO come. I also am very much into, with these behavior plans, I'm very much into Ross Green's work. Ross Green, if
Mhm.
for any of the listeners, um, want to go into the archives, actually, it's even on my YouTube channel, Sped Radio, 103.5. No, it's Sped Radio is my YouTube channel. I did an interview with Ross Green, and his philosophy on behavior plans is to do an assessment tool that he sees the kids that have behavior problems as having a disability with behavior. So learning disability with behavior. So he does the assessment of the ALSEP of lagging skills, the assessment of lagging skills and unsolved problems, because he feels a lot of times they have lagging skills that are not being taught, or they have an
Mhm.
unsolved problem they haven't talked to. Too often we superimpose issue on kids without really their input. And
Right.
if we can elicit the kids about what's going on with them, we can head things off at the pass. So, you know, just something to think about. It's called the ALSIP, the assessment of lagging skills and unsolved problems. The ALSIP.
ALSUP. ALSUP.
Mhm,
Okay.
mhm. It's
Um,
I've gotten some districts to actually buy into that. So, you know,
great.
yeah,
Another thing, Lou, I just mentioned it as we're about to close.
right,
We have a lot of advice for parents whose students have kind of a history of being in trouble, and you want to kind of, get out in front of some of that. Lou and I prepared a speech for COPA this coming up year, and we weren't chosen, but we have that, and I would be happy to do a show with you, Lou, and instead of giving it to COPA, give it on the show. And if the listeners are interested in that, maybe they could let you know, and then we could pick a time for that.
right. I mean, for sure. One thing, and part of that, and then we're going to have our sign off. One thing is that you need to be sure that the police are able to get a hold of the education records so that they know what they're dealing with if somebody has been referred for charges. And that's something that can help a criminal case. So, but it doesn't happen automatically. You have to give permission to be able to share that information with the police so that
And we
we,
have that form that we've created,
yeah.
sort of a guide for parents of how to get in front of that as well. So if you would like us to give you our COPA presentation that you won't hear at COPA, let us know and we can do it.
Okay.
Let Lou know, please, if you're interested.
Yeah, let us know. For issues regarding the show, you can go to SPED Radio, SPED Radio 103.5 at gmail.com, SPED Radio 103.5 at gmail.com. You want to contact me on my email, it's nationalardadvocates at gmail.com. Pat is P Freeze, PFREEZE at gmail.com. So we got National Art Advocates at gmail.com, Sped Radio 103.5 at gmail.com, pfreeze at gmail.com. And of course, we have my Twitter at Lewis, Louas at ARDA. Also, the radio station, Cypress Radio, accepts donations. They're not 501c3, but they accept donations to keep this show going and other programming. So that's cypressradio.org. You can give them any amount, so keeps the show running every week. But what passing words and wisdom if you have for our listeners, and then we'll say we'll see you on the radio and on the internet. What's your passing word, Pat?
Actually, I have a statement from the coach that we just talked about that I'm going to actually put on a t-shirt. He said, and I love this, I put it on my Facebook. What did he say? Oh, here it is. A lot of group work don't end well in that class.
Yeah.
And I think that's
yeah.
End well in that class.
I love that. I love that. Well, listen,
So,
as always, thanks for coming on the show. I'll see you all on the internet and the radio. Have you all self a really, really good week, and we'll see you all soon.
bye.